My father, Nathan Lewin, is a litigator, spends really an enormous percentage of his professional career working on religious liberty issues. The Jerusalem Post once called him the defender of the tribe. And while he's argued 28 cases before the Supreme Court, many of them dealt with religious liberty issues. So I grew up in this home where I heard about and got to watch him argue the case of Goldman versus Weinberger. That's the case that involves the right to wear a yarmulke in the military. He argued the case in the Supreme Court about the Chabad menorahs, the Hanukkah menorahs, and the right to put them up on public property. He argued the case of Kiryas Joel, which involved a Satmar community that established essentially a public school for their special needs children and the constitutionality of that school. Even before, when he was working in the government, he was the one who drafted the amendment to the 1964 Civil Rights Act that protected religious practice as opposed to just religion. So whereas you might not have been able to discriminate before then against somebody because they were Jewish, you could say, well, you can't work on Saturday. That's not discrimination. After the amendment, you couldn't discriminate against somebody on the basis of their religious practice. He drafted the comp time legislation that enabled government employees to take compensatory time so they wouldn't have to use up all of their vacation time to take off for the holidays. So I used to say that I don't think there's any legal initiative or effort that's touched the Jewish community that doesn't somehow have his fingerprints on it over the last half century. And that's the home I grew up in. And so maybe religious liberty issues are somewhat in my DNA. But that's why it seemed natural when I opened up a law practice together with my father, Lewin and Lewin, 14 years ago. And I should say it's still just the two of us and our office manager, who's also a paralegal. We continued to take on these kinds of cases. And I used to say our firm was essentially a magnet for all things Jewish. And so in addition to the Sabbath observer cases and employment discrimination cases, we've ended up representing Chabad Lubavitch Chassid, who wanted to be a New York City police officer, and they were insisting. He was in the police academy, he was excelling in the police academy, but they wanted him to shave his beard before he could get into the police force. And they said, once you're in, you can apply for an exemption because there are police officers with beards, but you can't come in with a beard. You have to shave your beard first. And we ended up bringing a lawsuit and winning that. And now he's a New York City police officer. We represented folks, again, in the military, the right to wear a beard in the military. We also broadened and have ended up bringing, on behalf of victims of terror, the first case in the United States that was against domestic groups that provided support for terror. So we brought the Boyne suit, which established the right of American victims of terror to sue these domestic groups. We sued the Holy Land Foundation for Relief and Development, and that established a legal precedent that was then used in the subsequent cases by victims of 9/11 against the Arab Bank. All those other cases are based on the Boyne precedent. And most recently, our most recent Supreme Court case, it was very nice of the Supreme Court to take it and hear it twice. So that way my father argued his 28th case before the court, and then I got to argue my first, the second time around, was the Zivotofsky case, which involved the right of an American citizen born in Jerusalem to have Israel listed as their place of birth on their U.S. passport. And while it was a blow when we lost that case, I will say, there's a Hebrew phrase, Gamzu Latova, this is also for the good. The court went so far, which it did not have to, as to announce in that and to hold in that case which branch of government has the authority to recognize foreign sovereigns. And the court held that the president has the exclusive authority to recognize foreign sovereigns. So should Donald Trump decide he can, on his own, recognize Israel's sovereignty over the city of Jerusalem, and that's the end of the matter. So now, why am I here? I'm here now to tell you about how religious liberty is under attack. Religious freedom, the freedom to act according to a set of religious principles, which is a principle that we Americans have taken for granted as one of the bedrock principles of our country, is now in jeopardy. Most people don't realize that it's the first 16 words of the First Amendment that protect religion. The first, it comes before press, before speech. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And yet, I'm sure that many of you have heard about the recent cases, the relatively recent cases, of the bakers in Colorado and in Oregon, or the wedding photographer in New Mexico, or the florist in Washington State, who on religious grounds said that they could not or would not provide services for same-sex marriages. And they were fined. They were fined. Some of them had to shut their businesses because they were held to have discriminated against same-sex the members of the LGBTQ community. Mitch had a piece, and I think the materials that Yoram distributed, which was excellent, which talked about a series of cases now that are out there which show this growing lack of sensitivity or support for the religious accommodations that are being requested. One of the cases that he talks about in that article, which I find particularly troubling, is the case of Stormans versus Weissman. And that was just now in June of this year. The Supreme Court refused to hear the case. That was a case where Washington State had a set of regulations that was passed by their Board of Pharmacy, which required all pharmacies in the state to stock and distribute drugs, including contraceptives, including emergency contraceptives that would include Plan B. And the Weissman, the Storman family is a devout Christian family that owns a pharmacy. Now, while the regulations provided that within an individual pharmacy, one pharmacist could object on religious grounds and have another pharmacist fulfill the prescription order, the regulations here specifically precluded one pharmacy from referring to another pharmacy that prescription. And that's the practice that Stormans had engaged in. If somebody would come to them and ask for a drug that they couldn't on religious grounds fill that prescription, they would send them to one of the 30 other pharmacies that were within a 5-mile radius, and nobody suffered. And yet, this regulation, when it was passed, specifically said that no, a pharmacy is not permitted and not allowed to do that. The district court had found that this practice was unlawful, essentially, but it was appealed, and the Ninth Circuit reversed. When they took it up to the Supreme Court now, in its state of 8 justices, could not muster the 4 votes necessary to take the case. So they did not take the case, which left the Ninth Circuit decision as the governing decision, which basically forces this pharmacy to either shut down or provide these drugs. And Justice Alito wrote a passionate dissent where he starts out the dissent by saying, this case is an ominous sign. And what's really troubling about it is he noted the facts that had been discussed in the lower courts, and said that when the board began to consider these regulations, the governor of the state sent a letter to the board opposing referral for personal or conscientious reasons. The State Human Rights Commission followed up on the governor's letter and told the members of this board that they would be held personally liable if they passed a regulation permitting referral for religious or moral reasons. And the initial vote of the board was to allow for those referrals for religious reasons. And when the governor learned of that, the governor sent another letter opposing those draft rules and publicly explained that the governor could remove the board members if need be, if they were going to create a draft that went the other way. So the executive director of the board realized that it was clear that their task was to draft language that could allow referrals for any other non-religious or non-moral reasons, but not for religious reasons. So there were 38 pharmacy associations, 8 national and 33 state, that filed an amicus brief with the Supreme Court, urging them to take the case, because they said this kind of facilitated referral benefits the public, because if you're going to force this pharmacy to shut, then that takes one pharmacy out of circulation, people have less of access. It makes it more difficult for them to get the medications. And Washington State even stipulated in the case that this facilitated referral did not pose a threat to anyone receiving timely access to their lawfully prescribed medication. And yet, nonetheless, the situation now is that regulation was allowed to stand. So what's the history of the way we've been protecting religious liberty? Prior to 1990, the standard used to be that a government law the government had to demonstrate a compelling state interest that would justify any kind of imposition on the religious practice, and that imposition that had to be by the least restrictive means to reach that government objective. This changed in 1990 with the case of Oregon v. Smith, which involved the use of peyote by Native Americans for religious purpose. And in that case, the Supreme Court basically did away with the compelling state interest test and held that as long as a state law is neutral on its face, as long as the law doesn't specifically target religion, then the law trumps religion. The religious practice goes by the wayside. So that would mean, for instance, if you had a law that said circumcision is not permitted, or a law that said kosher slaughter is not permitted, there'd be no recourse. So after Oregon v. Smith, there was kind of general panic, certainly in the religious communities, and right and left both recognized the need to insert this compelling state interest test back into the law. So that's when the Religious Freedom Restoration Act was passed, otherwise known as RFRA. And it's really interesting. If you look, this shows you'll see how far we've come. When President Bill Clinton signed RFRA, this is what he said. "We have a shared desire here to protect perhaps the most precious of all American liberties, religious freedom." Went on, "The free exercise of religion has been called the first freedom, that which originally sparked the development of the full range of the Bill of Rights. Our founders cared a lot about religion. They knew that religion helps to give our people the character without which a democracy cannot survive. They knew that there needed to be a space of freedom between government and people of faith that otherwise government might usurp." And then he closed by saying, "Let us respect one another's faiths, fight to the death to preserve the right of every American to practice whatever convictions he or she has, but bring our values back to the table of American discourse to heal our troubled land." That was Clinton. Well, the federal RFRA lasted 4 years. In 1997, the Supreme Court struck it down and said that the Congress had gone too far and overstepped by imposing RFRA on the states. So then it became necessary for the states to pass their own individual RFRA laws. And over the years, by 2014, you had about 20 states that had enacted state RFRAs, about 11 states whose courts had kind of recognized the RFRA protections even without state RFRAs. But then came the passage of the Affordable Care Act and Obamacare. And Obamacare created this tension now between religious rights and abortion rights. By requiring employers to provide comprehensive health insurance to their employees, and health insurance that would include free access to all contraceptives, including these emergency contraceptives like Plan B, set up that conflict, set up that tension. So then you ended up with the cases of employers saying, we can't on religious grounds provide this. So in June 2014, the Supreme Court upheld in Hobby Lobby, it exempted a privately owned company or owned by a religious, devout Christian family from that requirement. But in the Hobby Lobby case, in her dissent, Ruth Bader Ginsburg noted, "Accommodations to religious beliefs or observances must not significantly impinge on the interests of third parties." In other words, you can practice your religion as long as it doesn't affect anybody else. In reaction to the Hobby Lobby decision, the narrative developed that religious accommodations are now threatening social progress. And that continued with the Obergefell case, which was the same-sex marriage case. And in oral argument at that case, Justice Alito asked the Solicitor General, he said, this is Alito, well, in the Bob Jones case, Bob Jones is an earlier Supreme Court case where the IRS had removed tax-exempt status from Bob Jones University when Bob Jones University had opposed interracial relationships. So Alito says, well, in the Bob Jones case, the court held that a college was not entitled to tax-exempt status if it opposed interracial marriage or interracial dating. So would the same apply to a university or college if it opposed same-sex marriage? That's Justice Alito. The Solicitor General, Verrilli, answered, you know, I don't think I can answer that question without knowing more specifics, but it's certainly going to be an issue. I don't deny that. I don't deny that, Justice Alito. It is going to be an issue. David Bernstein, in a recent piece in the Washington Post on the Bolt blog, the legal blog, claimed that that argument, that oral argument in that moment is what cost the Democrats the election. There have been an enormous backlash against RFRAs, which are now interpreted as this effort to ensconce in the law the right to discriminate against members of the LGBTQ community. And the courts have been split on whether RFRA applies to these private litigants, like the baker and the florist. So last year, in 2015, Indiana tried to enact a state RFRA that would explicitly cover these private litigants. And boy, the response, the attacks were fast and furious. There were states that said, like Connecticut and the city of San Francisco, that they would stop all state-sponsored travel to Indiana. There were companies that threatened to boycott Indiana. Even though RFRA doesn't work that way, they went out there in Indiana, reporters, to try and prove this. And an example is they came up with a pizza parlor. A pizza parlor. Who has a pizza parlor cater a wedding? But they found a pizza parlor which had a sign that says that, and so you know you're going to get this pizza parlor. The pizza parlor put up a sign that says, every day before we open the store, we gather and pray together. If there is something you would like us to pray for, just write it down and drop it in the box and we will pray for you. Oh, that's a good bet. Let's go to that pizza parlor and ask them if they'll cater a same-sex wedding. So they go, and these are reporters. These aren't individuals who want a same-sex wedding. Would you cater a same-sex wedding, they say to the pizza parlor owner? Well, you know, we've never been asked that question. We don't really anticipate ever being asked that question. We serve anybody who wants to come to our pizza parlor. They're all welcome. We've never turned anybody away. But I guess if we were asked to cater a same-sex wedding, we'd have to decline. Well, boom, in the press, they're pilloried, attacked. Proof that Indiana citizens want to discriminate against members of the same-sex community and marriage community. And ultimately, Indiana is pushed very shortly after they passed this to pass an amendment that removes the language that would have covered these private litigants. So there's a little more. You should know that now in September, the chairman of the U.S. Commission on Civil Rights issued a report on protections against discrimination. And he said in his report, basically, that Americans need to be protected against the religious. He says here, the phrases religious liberty and religious freedom will stand for nothing except hypocrisy, so long as they remain code words for discrimination, intolerance, racism, sexism, homophobia, Islamophobia, Christian supremacy, or any form of intolerance. That's the way religious liberty and religious freedom is now being looked at by those who feel that the religious community is using these protections and these exemptions to discriminate against the members of the LGBTQ community. And I just want to say, how far have we come in terms of society's perception of same-sex marriage and same-sex relationships? Back in 1967, I'm going to come back to my father right now, he was working in the office of the Solicitor General, and he argued a case in the Supreme Court that was called Boutillier versus the Immigration and Naturalization Service. This is 67. It's not even 50 years ago. Mr. Boutillier was a Canadian and a homosexual. And the Supreme Court ruled in that case, my father won it for the government, that Mr. Boutillier could be deported as a psychopath because he was a homosexual. The court held that the statute, which excluded from admission to the United States aliens afflicted with psychopathic personality, that language, that statute was without a shadow of a doubt intended to include homosexuals in that definition. So the cultural attitude towards same-sex relationships has now come 180 degrees, and the result now in terms of religious protection is we're moving back in the other direction. Just one quick additional item is, in addition to RFRAs, the answer may reside with what Utah has done. Utah, seeing the writing on the wall before the Supreme Court's decision in same-sex marriage, passed kind of a compromise legislation. They have come up with a law that protects religious liberty while at the same time protecting against discrimination. And there's a professor, Robin Fretwell Wilson at the University of Illinois, who's talked about how now what's happened is you have these same fundamental values of personal liberty that support an individual's right to follow and fulfill their sexual identity, whether inside or outside of marriage. They also support an individual's right to live according to his or her religious convictions. And what we have to do is find that line that enables both of these groups to be respected, both of these groups to live their lives without interference from the other, right? Let me live my religion in peace. I should not, if I'm the baker, be compelled. If I'm the pizza parlor owner, if I'm the florist, I shouldn't be compelled if there's another florist or another baker or another pharmacist or another photographer. You shouldn't be permitted to compel me to, or push me to violate my religious beliefs when you can go to somebody else. It shouldn't be a win-lose situation. We should be able to find that line and work out that compromise.